Rhode Island has a moderately regulated tenant screening environment with several state-level provisions that go beyond the federal FCRA baseline. Rhode Island's overall regulatory approach leans tenant protective, and landlords need to understand both the state-specific requirements and the practical dynamics of screening in one of the smallest and most densely populated states in the country. Let's start with application fees. Rhode Island has a specific provision that limits what landlords can charge. Under Rhode Island General Laws Section 34-18-36, landlords cannot charge an application fee that exceeds the actual cost of the screening. This means you can only pass through to the applicant what you actually pay for the credit report, criminal background check, and related verification services. You cannot add a markup, administrative fee, or profit margin on top of the actual screening cost. If your screening provider charges $30 for a comprehensive report, you can charge the applicant $30, not $40 or $50. If you use a provider that charges less, your fee must reflect that lower cost. Landlords who charge more than their actual screening cost are in violation of the statute and can face liability. Rhode Island also requires that if the landlord doesn't actually conduct the screening, for example, if the unit is rented before the screening is completed, the fee must be refunded. Best practice is to keep receipts or invoices from your screening provider to document your actual cost in case a fee is ever challenged. Criminal history screening in Rhode Island is affected by several state-level provisions. While Rhode Island does not have a comprehensive ban-the-box housing law with the detailed procedural requirements found in Washington, D.C. or Seattle, the state has enacted reforms that affect how criminal records can be used. Rhode Island's expungement and sealing laws have been expanded in recent years. Landlords cannot consider criminal records that have been expunged or sealed under Rhode Island law. Rhode Island also allows for certificates of recovery and certificates of good conduct that are intended to demonstrate rehabilitation. While landlords aren't required to accept these certificates as dispositive, they are relevant to any individualized assessment. Providence, the state's capital and largest city, has been active in discussing additional tenant protections, including criminal history screening restrictions. Landlords operating in Providence should monitor local ordinances and policy discussions that may impose additional requirements beyond state law. The political environment in Providence strongly favors tenant protections, and additional screening restrictions are a realistic possibility. HUD's 2016 guidance on criminal history and disparate impact applies in Rhode Island. The state's tenant protective legal culture means that overly broad criminal history policies face a higher risk of challenge than in more landlord-friendly states. Rhode Island landlords should apply criminal history criteria that consider the nature and severity of the offense, how much time has passed, evidence of rehabilitation, and the relationship between the offense and the tenancy. Document your analysis for each applicant to create a defensible record. Source of income protection in Rhode Island is established under the state's fair housing law. Rhode Island General Laws Section 34-37-4 prohibits discrimination in housing based on several protected categories, and the state's interpretation of its fair housing provisions has extended protections to tenants who receive housing assistance. Landlords cannot reject applicants solely because their income comes from housing choice vouchers, Social Security, disability payments, or other lawful sources of income. The practical effect is that Rhode Island landlords must evaluate voucher-holding applicants on the same basis as market-rate applicants. If the voucher payment plus the tenant's personal contribution meets your income requirement, the applicant qualifies, and the source of that income cannot be the basis for rejection. Advertising that you don't accept vouchers or government assistance violates Rhode Island law. The Rhode Island Commission for Human Rights investigates source of income discrimination complaints and has enforcement authority including damages, injunctive relief, and civil penalties. For credit reports, Rhode Island follows FCRA requirements for permissible purpose and written consent. The adverse action process follows federal requirements. Rhode Island does not impose significant additional state-level requirements for credit report access beyond FCRA. However, given the state's tenant protective environment, providing detailed written explanations for denials, beyond the minimum FCRA requires, is a smart practice that reduces dispute risk. Rhode Island's fair housing protections under the Rhode Island Fair Housing Practices Act, found in General Laws Title 34, Chapter 37, are broader than the federal baseline. Protected categories include race, color, religion, national origin, sex, sexual orientation, gender identity and expression, disability, familial status, marital status, age, and housing status. The inclusion of sexual orientation, gender identity, marital status, age, and housing status goes substantially beyond federal protections. The housing status protection is particularly noteworthy and relatively unusual. This provision is intended to protect individuals who are experiencing or have experienced homelessness from discrimination in the screening process. Landlords cannot reject an applicant solely because they are currently homeless or have a history of homelessness. The applicant must still meet your legitimate screening criteria: income, creditworthiness, rental references. But the fact that they are currently without housing or have gaps in their rental history due to homelessness cannot be the reason for denial. This housing status protection has practical implications for how landlords evaluate applicants with gaps in their rental history. Rather than automatically rejecting applicants who can't provide recent landlord references because they've been homeless, landlords should evaluate the applicant based on available criteria: income verification, employment history, character references, and any other information that demonstrates ability to pay and maintain the property. From a practical standpoint, Rhode Island is the smallest state in the country by area, and its rental market is concentrated and interconnected. The entire state functions almost as a single metro area, with most communities within commuting distance of Providence. Providence is the dominant rental market driven by healthcare, including Lifespan Health System and Care New England, higher education, Brown University, Rhode Island School of Design, Johnson and Wales University, Providence College, and the University of Rhode Island's Providence campus, government, financial services, and a growing creative economy. Providence has a diverse tenant population that includes students, young professionals, healthcare workers, immigrants, and lower-income residents who rely on housing assistance. Providence's rental market is tight, with limited supply and strong demand driving rents higher. The city's tenant advocacy community is active and well-organized. The Rhode Island Center for Justice and other organizations provide legal assistance to tenants and actively pursue fair housing complaints. Landlords in Providence should assume that non-compliant screening practices will eventually be challenged. Warwick, Cranston, and Pawtucket, the state's next largest cities, have more moderate markets but are still relatively tight given Rhode Island's overall housing supply constraints. These communities are within the Providence metro area and share its general market dynamics. Newport has a unique rental market driven by tourism, the naval presence, Naval Station Newport is a significant employer, and the city's historic appeal. The military population at Naval Station Newport represents a meaningful portion of the rental market, and landlords should understand military income documentation, leave and earning statements, and BAH rates. Newport's BAH rates reflect the area's higher cost of living. The seasonal tourism economy in Newport, Narragansett, and other coastal communities creates temporary workforce housing demand during the summer months. Screening seasonal workers requires clear criteria for evaluating temporary income that you apply consistently. Kingston, home to the University of Rhode Island, has a student-influenced market. Screening students with limited credit and rental history is routine in this market, and having a clear cosigner or guarantor policy applied uniformly is essential. Woonsocket, Central Falls, and some of Rhode Island's smaller communities have more affordable markets with higher concentrations of tenants receiving housing assistance. Source of income protection is particularly relevant in these communities. Landlords cannot screen out voucher holders, and the tenant population regularly includes applicants paying with government assistance. Rhode Island's small size creates a practical dynamic that affects screening. Reputation matters enormously. In a state where the entire landlord community is interconnected and tenant advocacy organizations are well-networked, a pattern of discriminatory screening practices will become known quickly. Fair housing testing is conducted in Rhode Island, and complaints are actively investigated. The reputational cost of non-compliance in a small state can be significant, well beyond the direct legal penalties. One best practice for Rhode Island landlords: document your actual screening cost with invoices or receipts from your provider, and charge applicants only that amount. If your screening cost changes because you switch providers or your provider adjusts pricing, update your application fee accordingly. Overcharging on screening fees is a straightforward violation that's easy for regulators to identify and enforce. Another best practice: develop clear criteria for evaluating applicants with non-traditional backgrounds, including applicants experiencing homelessness, applicants with gaps in rental history, and applicants whose income comes entirely from public assistance. Rhode Island's housing status and source of income protections mean you'll regularly encounter these applicants. Having documented consistent criteria for evaluation, rather than defaulting to automatic rejection, keeps you compliant and expands your qualified applicant pool. A third best practice: given Rhode Island's broad protected categories, train anyone who interacts with applicants, leasing agents, property managers, maintenance staff, on the state's fair housing requirements. Rhode Island protects sexual orientation, gender identity, marital status, age, and housing status in addition to the federal categories. Casual comments or questions during showings or application processing that touch on any of these categories can form the basis of a discrimination complaint. Rhode Island limits the security deposit to 1 month's rent. The landlord must return the deposit within 20 days of the tenant vacating. The limited deposit, combined with Rhode Island's tenant-protective legal environment, makes thorough, compliant screening your single most important tool for selecting reliable tenants and protecting your investment. For the complete guide to Rhode Island tenant screening laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel for every state in our tenant screening law series.